Hosting our program is James Shirk, Senior Policy Analyst in Labor Economics in our Center for Data Analysis. He joined us in 2006 and researches ways to promote competition and mobility in the workforce instead of erecting barriers preventing workers from getting ahead. His commentary and analysis has appeared in major newspapers. He is also a guest expert on major network news shows. He earned his bachelor's degree in economics and mathematics at Hillsdale College, and he received his master's degree in economics with a concentration in econometrics and labor economics from the University of Rochester in New York. Please join me in welcoming James Shirk. James.
Thank you. Right to work is a perhaps surprisingly controversial topic. You'd think it'd be a fairly fundamental American value that you can't force someone to give you money, that if you want to voluntarily support an organization, you have the freedom to do so, but the organization can't simply turn around and say you have to pay us. But that's actually not the case. It turns out that unions typically put into their contracts they negotiate provisions that make union representation a condition of, or union dues a condition of employment, and that in the absence of a right to work law that makes it clear that the union dues are voluntary, workers will get fired if they don't pay dues. And so we now have 24 states that have passed right to work laws. However, progress in right to work has been slow. After the period in the 1940s and the 1950s, when a large number of states passed right to work laws, there hasn't been a whole lot of movement since. In fact, in 2012, when both Indiana and Michigan passed right to work laws, they doubled the number of states that had passed right to work laws in the previous 25 years. You had to go back to 2001 in Oklahoma and then 1987 for Idaho, were the previous two states to pass right to work laws. And the consequence of this is that workers in a majority of American states are compelled to support organizations that in many cases they vehemently oppose the agenda of that organization. And in other cases just don't believe that they're getting value for the 1 to 2% of their paycheck they're forking over. And it also hurts business development in these states because union organizers, they get a lot more aggressive when if they organize the company successfully, every worker in that company has to pay them 1 to 2% of their salary for the rest of their working life with that firm. They get a lot more aggressive in their organizing tactics. And businesses want to know that if they treat their workers well and they treat them with respect, the unions are going to leave them alone, that unions are only going to come in and organize workers where, as the old saying puts it, management gets the union they deserve. That if management treats the workers well, they want to know the unions aren't going to be bothering them. And if they don't treat the workers well, they deserve what they get. But as a result, it's no accident that Boeing chose to locate their new facilities in South Carolina, a right-to-work state. It's no accident that most of the transplant auto manufacturers chose to locate in right-to-work states like Tennessee, South Carolina, Mississippi, Alabama. They did that on purpose. They did that because they did not want the United Auto Workers constantly breathing down their necks. But what do you do if you're, say, someone in Kentucky, someone in Ohio, someone in Pennsylvania, where the state appears unlikely to pass right to work? Well, for many decades, people have assumed this could only be a statewide law. But in fact, in a new paper that I published with my co-author Andrew Kloster, we argue that there are strong legal and very good public policy arguments for local city governments and counties passing their own right-to-work ordinances. So to discuss this innovative new possibility, we've assembled a great panel here. My co-author, Andrew, here is a legal fellow in the Edwin Meese Center for Legal and Judicial Studies here at the Heritage Foundation. And before joining Heritage, Andrew Kloster was a legal fellow at the Philadelphia-based Foundation for Individual Rights and Education. And he is also the author of several law review articles. We also have joining us William Messenger, who's a staff attorney at the National Right to Work Legal Defense Foundation. He received his Juris Doctorate from George Washington University. And he's also argued several cases before the Supreme Court, including his recent victory in the Harris v. Quinn case that was handed down this term. So we're very pleased to have someone with his legal expertise here to discuss this. We also have Patrick Gleason, who's the Director of State Affairs for Americans for Tax Reform, and he's also a contributing writer for Forbes magazine. And we have Councilman John Russell, who's the Director of the American City County Exchange, which is a nationwide network of village, town, and city and county lawmakers, which seeks to advance efficiency, limited government, and free market principles at the local level. This is an initiative of the American Legislative Exchange Council. And in addition to all these duties, John is a councilman in Culpeper, Virginia, where he sits on many local city council counties there. So with that, Andrew, why don't you give everyone an overview of what we found on the paper?
Sure. Should I go up there?
It's up to you.
Okay, I think I'll just stay here. Labor law is a very complicated area. Many regulatory areas in the U.S. are, so I'll try to make this as simple as possible. Federal law, we know from the Supremacy Clause in the Constitution, valid federal law, that is, federal law passed pursuant to an enumerated power of Congress, valid federal law trumps state law. So when there's a conflict between state law and federal law, the federal law wins. However, consistent with our constitutional structure, when there is confusion as to whether federal law actually does preempt, is the technical term here, whether federal law actually does preempt state law. When there's confusion over that, the tie goes to the states. There's a thumb on the scale of state and local governments because we want to push as much decision-making down to the local level as possible. So in this context that we're talking about today, we have a federal law, the National Labor Relations Act, also known as the Wagner Act, that was passed in 1935. And it's a big, complicated statute. Parts of the law are intended to be the final word on the subject. They're intended to preempt state and local law. Other parts of the law leave it to local innovation and state and local initiatives to fill in the gaps. One of those areas where we think the federal government left it to the states and locales to decide is right to work. Now, when the law was passed in 1935, this wasn't exactly clear. And in a Supreme Court case, Hill versus the state of Florida in 1945, the Supreme Court held that the NRLA did preempt state right-to-work laws. But Congress came back and said, whoa, 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 that's a mistake. We did not mean that. We didn't mean to do that, so we're going to overrule this statutory interpretation of the decision of the Supreme Court. And in 1947, the late great senator from Ohio, Robert Taft, they passed the Taft-Hartley law, which is still good law, and it says, and it's codified at 29 U.S.C. 164, and it says, agreements requiring union membership in violation of state law, that's the title of the section. Nothing in this subchapter shall be construed as authorizing the execution or application of agreements requiring membership in a labor organization as a condition of employment in any state or territory in which such execution or application is prohibited by state or territorial law. So let me translate this to plain English. Congress in 1947 came back and clarified, and they said, we do not intend federal law to stop states and territories from passing right-to-work laws. We don't intend that at all. And so now that is on the books, that's good law, and we know for a fact, as James mentioned, 24 states have passed right-to-work laws. But what about local right-to-work laws? What about local right-to-work ordinances? Here's where it gets murky, because Congress came back, and in 1947, there were no local right-to-work ordinances on the books. There were very few home rule jurisdictions, and so really the only game in town was state or territorial right-to-work laws. So the question is this: when Congress in 1947 passed this law, and they explicitly said, we're going to let states and territories pass right-to-work laws, did they also mean we're going to prohibit local right-to-work laws? Now, I personally don't think that's the case, and it's certainly not clear. And that's the important thing, because where it's unclear, the tie goes to the jurisdiction trying to pass their own law. Where it's not clear that federal law preempts state law, it's up to states. They have freedom to pass laws. So there have only been a handful of cases on point and a handful of decisions on point, precisely because this was not an issue for the intervening over 50 years. The first case that we have is in 1965, and this was the highest court in Kentucky at the time, in a case called Kentucky State AFL-CIO v. Puckett, struck down a local right-to-work ordinance on the grounds that federal law did preempt local right-to-work ordinances. The main argument that they made in that case was that Section 14B, which is the 1947 law, would be superfluous if it also included an exception for local right-to-work laws. I'm sure Bill will talk a little bit more about some of these arguments, such as the superfluity argument, but suffice it to say that there are a variety of I think, drafting errors that are obvious ones in other areas of the NLRA, and this might be one of them. I mean, in this case, for example, they left off tribes. Why did they leave off tribes? And we have other decisions saying that tribes are included in the exception. So it's not at all clear what Congress meant to do in 1947. Then we have a Missouri Attorney General letter in 1987 where the AG, in an informal opinion that's not at all official, basically said, I also think that federal law preempts local right-to-work statutes. So now this is now 40 years after the fact, and someone's coming out and saying, not on the record, but in sort of an informal opinion, I think that you can't do this sort of thing. There was really no analysis in that opinion at all. The first federal court case that we have on point is in 1990. So now we're talking almost 45 years after Taft-Hartley was passed. We finally have a federal court, district court, weigh in on this issue, and it's New Mexico Federation of Labor v. City of Clovis. We discussed this case at some length in our paper. Basically, again, the district court argues that if local right to work were allowed, that would render 14b rather superfluous. It argues that Congress may have intended to allow 50 jurisdictions to experiment, but it certainly didn't intend thousands of jurisdictions to experiment, and that would make the law unworkable. There are a variety of other arguments that one could make in support of that opinion, but it's all a bit of a moot point because later on, the 10th Circuit came back and may have overruled that decision. In another case that came down, which we also discuss at some length in the paper, which is NLRB versus Pueblo of San Juan, also coming out of New Mexico. In that case in 2002, which is the last federal case on point, and this is the 10th Circuit, the Federal Appeals Court, the 10th Circuit said that tribes are included in 14b even though they're not explicitly mentioned, or at least that it's not clear that Congress meant to exclude tribes. There's a little bit of play in the joints between this case and City of Clovis, but it certainly seems like the 10th Circuit implicitly overruled City of Clovis. So what does all this mean, basically, to bring it back down to earth? What this means is that we have very few court cases on point. They kind of go both ways. They don't have full analyses. And the last word on the subject is a 10th Circuit case which sort of implicitly suggests that locales ought to be allowed to pass right-to-work states. All of this is to say that it's not clear that Congress preempted local right-to-work ordinances, and if it's not clear, the bottom line is that they are free to do so. And I think that's the main point of our paper, is that because there's no clear federal law on point that consistent with constitutional principles of federalism, locales should feel free to exercise their rights. This is a particularly good argument where you have explicit authorization by a state government for a locale to go and pass legislation if you have a home rule state or a charter rule jurisdiction, where the state actually says, we bless you to go forth and pass your own laws. If one of those laws is a labor law, that certainly looks like it's an authorization of a state. It may constitute state law, and it's certainly consistent, I think, with the understanding that Congress had when they passed the Wagner Act, which is to leave in place the ability of states and locales to experiment and to leave in place the traditional, some of the traditional labor and employee relationships. So with that, I'll turn it over to whoever is next. Bill?
Yes, thank you. And today I'd just like to address sort of the narrow legal question of, would it be legal for a locality, a city or a county, to enact a right-to-work law? And I think the answer is it depends and maybe. The first question comes under state law, and this is the it depends, is could a county or a city in any particular state, does it have authority under state law to actually pass a law regulating labor relations? And that really becomes a question dependent. Is it a home rule jurisdiction? Is there any kind of incompatible state law that precludes that? And there's not really too much that could be said about that because obviously this varies, amongst the 26 non-right-to-work states. But for any locality considering a right-to-work law, the first thing, to be researched rather heavily is, can we do this under state law, not even withstanding the federal issues? And then the second question becomes, if they could do it under state law, can it be done under federal law without it being preempted by the National Labor Relations Act, which Andrew was discussing a little bit before. And as Andrew mentioned, it's basically an open question. All the opinions on this are from lower state court levels and one federal district court opinion in New Mexico, which may no longer be good law. No appellate court has directly spoken on it, and neither has the Supreme Court. And so the question then is, what are the arguments that a locality could make in favor of its ability to pass a right-to-work law without being preempted by the National Labor Relations Act? And unfortunately, this requires getting into the weeds a little bit of the National Labor Relations Act. And really what you're dealing with here is an exception to a prohibition under federal law. Full employment for labor lawyers is the reason why. So again, exception to a prohibition. The prohibition is Section 8A3 of the National Labor Relations Act. It says it's an unfair labor practice for an employer to discriminate in terms and conditions of employment to encourage or discourage union membership. A compulsory unionism clause, where an employer says, I'll fire you if you don't join the union, obviously violates 8A3. So the general prohibition of 8A3 actually requires right to work. But then there's an exception. Right in 8A3, it's often called the union shop proviso, and it says that nothing in the subchapter shall make it illegal for a union and employer to enter into a compulsory unionism clause. I'm paraphrasing, of course, but basically it's an exception that allows compulsory unionism clauses. So now you have an exception to 8A3. And then you have another exception under the National Labor Relations Act under 14B, which says, notwithstanding anything in the NLRA, nothing shall require the authorization or enforcement of a compulsory unionism clause in any state or territory where such an agreement would be prohibited by state or territory law. So Congress creates an exception to 8A3 for compulsory unionism clauses and then says states can basically invalidate that exception with what are commonly called right-to-work laws. So with that framework in mind, what would be a locality's argument that its local right-to-work law would not be preempted? And there's really two. The first is that such a law would be covered by 14B. And again, 14B applies to, it says, in which such execution or application of an agreement is prohibited by state or territorial law. And so the argument would be the law of a locality is effectively not something that means it's not prohibited by state law. And that by state law, Congress was including the lesser with the greater. By reference to state, it means within a state, not just laws from the state itself. And this argument could be bolstered in situations where you have a locality that is considered a subdivision of the state. Because then it could be said, yes, this is effectively a state law or part of the state law. And as indicated in Andrew's paper, and James' paper, there's a lot of ambiguity there of what exactly did Congress mean. And there's a strong argument made that when Congress said not prohibited by state law, they meant the law within a state. They weren't focused just on the higher level of decision-making within any state body. And this is consistent with other cases in which the term state law or things like it were construed to mean laws within a state. And it's certainly a whole lot more plausible than the argument you're seeing made today under the Affordable Care Act, where they're saying state healthcare exchanges covers federal-run healthcare exchanges. So I think to say that state law encompasses laws within a state is certainly a viable argument. And then the second argument is, okay, even if 14B doesn't allow a right-to-work law by a locality, it doesn't necessarily mean it's preempted. In a case called Algoma Plywood, the United States Supreme Court in 1949 held that prior to the enactment of 14B in the Taft-Hartley Act, states could pass right-to-work laws. Because again, you had the Wagner Act, the original right-to-work, or the original National Labor Relations Act, had something very similar to 8A3, but did not have 14B yet. And however, there were also about a dozen right-to-work laws at that time. And so the question became, were those right-to-work laws preempted by the National Labor Relations Act? And again, this was before it was amended to add 14B. And the Supreme Court in Algoma Plywood said no. The proviso to 8A3, which allows compulsory unionism agreements, is merely an exception to the general law. It doesn't require compulsory unionism clauses. And the court also relied very heavily on legislative history from the Wagner Act, in which Congress was sort of making clear we weren't intending to interfere with state regulation of the closed shop, as they called it then. So an argument can be made that even if 14B doesn't cover, this still isn't preempted by 8A3. Now the question becomes then, well, why did they put 14B in if it was already not preempted? And the answer is to make it 100% clear. Because again, Algoma Plywood was decided in 1949. That was 2 years after Taft-Hartley. When they were debating Taft-Hartley, it was a debatable point. Who knows what the Supreme Court would rule? So the court, or the Congress, wanted to make 100% clear that the National Labor Relations Act in 14B did not preempt right-to-work laws. And this is actually similar to what they did in another area. Prior to the Taft-Hartley Act, Congress, or the Supreme Court held that the NLRB couldn't basically require that employers not speak against unions. It held that would violate the employer's First Amendment rights. But to make clear that there's no way the NLRA reached free speech, they added Section 8C to the National Labor Relations Act, which provides that it cannot be an unfair labor practice for an employer to engage in speech that doesn't have a threat or a promise of benefit. And again, the fact they passed that clarification doesn't mean that employers no longer have a First Amendment right to speak. It just makes that more clear. 14B was basically enacted the same way. And perhaps the strongest support for this comes from a circuit court opinion, which Andrew mentioned, and that's Pueblo of San Juan. And the question there was, can an Indian tribe enact a right-to-work law? Now, a lot of the opinion, or some of the opinion, did deal with things rather peculiar to Indian tribes and the fact that they're sovereign nations to a large degree. But the court also relied on the fact that even without 14B, the NLRA did not preempt right-to-work laws. And what the court said, and I think this is worth quoting, quote, "What Congress has not taken away by 14B, it need not give back by, what Congress has not taken away by 8A3, it need not give back by 14B in order for the tribe to continue to have authority to pass a right-to-work law." And I think that exact same logic would apply to a locality, that attempts to enact a right-to-work law. And for this reason, the district court decision, City of Clovis, which was for a court lower than the 10th Circuit, may have been implicitly overruled by Pueblo of San Juan on that basis, because City of Clovis was really dependent on the idea that if you don't fit within 14B, you lose. Well, Pueblo of San Juan says that isn't necessarily true. And so those are the arguments that a locality could make in favor of its authority to enact a right-to-work law. Whether those arguments would be accepted, no one can say with assurance. Again, it's an open question. It hasn't reached the appellate courts or Supreme Court, but a locality would at the very least have a viable argument to fight back against the inevitable lawsuits that would be filed against it if attempted to enact a right-to-work law. With that, I'd like to pass on to James for the next topic.
Patrick, if you could talk to us about the benefits that right-to-work would bring to cities and counties that passed it at the local level.
Yeah, well, so I'm Patrick Gleason, head up ATR State Government Affairs Department, and Americans for Tax Reform is known for working on tax and budget issues, but both ATR and our affiliate labor group called the Center for Worker Freedom are also big proponents of right-to-work laws, and we were very supportive of the recent reforms in Michigan and Indiana, and we're very excited about the prospect of passing these pro-growth reforms at the local level. And there's a number of reasons why we support right-to-work laws. Both it's pro-worker, promotes worker freedom, freedom of association, but we also notice that right-to-work laws are pro-growth laws that help foster economic growth and actually tend to coincide with more competitive tax codes and reduce tax burden. So, I'll walk through a few things. Right-to-work states, with those laws in the books, outperform non-right-to-work states on almost every, metric of economic health, from lower unemployment rates to greater GDP growth to higher per capita income. Just looking at the last decade, real GDP growth was 17% in right-to-work states from 2004 to 2013. In non-right-to-work states, it was only 10%. So 70% greater GDP growth in right-to-work states versus non-right-to-work states. So we're very supportive of that, of the law for that reason, and that it fosters economic growth. But also, I want to point out the lower tax burden that right-to-work states tend to have, and we could see these same dynamics if it was implemented at the local level. So you've got average state and local tax burden combined in right-to-work states is not just lower than the national average, it's even more lower than right-to-work states. So, for right-to-work states, it's 8.34% of income, or just a little over $3,500 per capita, is the average state and local tax burden in right-to-work states, which is lower than the national average of 9.8%, and it's even far lower than the average for non-right-to-work states that have a much greater state and local tax burden on average. They have a 10% average state and local tax burden compared to the non-right-to-work states, which is under 9%. So big difference. Also, if you look at right-to-work states, the average top marginal income tax rate in the state versus non-right-to-work states, you see a significant difference. It's average top marginal income tax rate is 4.61% for right-to-work states. This is below the national average of 6.29%, and even farther below the average top marginal income tax rate for non-right-to-work states, which is much higher, 6.79% top average rate. And then on the corporate side too, average state corporate tax for states with right to work on the books is 5.45%, which is lower than the national average of 6.56%. And then the non-right to work states where you have compulsory union membership, you see an even higher corporate tax rate than you have on national average. And in right to work, they have a 7.32% top corporate rate. So these laws foster greater economic growth, prosperity. They also tend to coincide with, more limited taxation, more competitive tax codes. And this is not surprising because traditionally, historically, labor unions tend to be some of the biggest, most powerful advocates for higher taxes at the state level and the local level. So it's not surprising that we'll see in states that have, where union membership is compulsory and can be coerced, tend to have higher tax burdens. So it's not surprising, but, stark comparison to point out. So we're very excited about the prospect of getting this done in localities where the state legislature is an obstacle. And there's actually some precedent for this on another labor reform, not right to work, but as far as paycheck protection, which is laws that prohibit the use of government resources and payroll systems to deduct union dues. We're very supportive of that. There was in Colorado, which is currently controlled by a Democratic governor, House and Senate, although that might change the state Senate after this November, but have always had Democrats either in total control or controlling part of state government for the last, better part of the last decade. And 8 years ago there, while we could not get right to work done at the state level through the legislature, a number of ballot measures were placed on local ballots. And Centennial, Colorado, Englewood, and Greeley, they had local paycheck protection measures put up to voters through the ballot process. And it passed in Centennial, and it was defeated in Englewood and Greeley. But you can see that, there's precedent. If you can't get, good pro-growth, pro-worker reforms done at the state level, why not go and try to do it at the local level? And I think with this proposal, you can see localities and states where they're not going to do this at the state level. If they move ahead with this, you can see them becoming hubs of, economic activity and investment and become much more attractive because, site selection managers will tell you right to work laws are one of the most important things when they are determining prospective locations. So those are some of the top reasons why Americans for Tax Reform and our affiliate group, Center for Worker Freedom, are very supportive of this new proposal, and we're really excited about the prospects for getting this done at the local level.
And John, could you talk to us about the interest that you think there would be at the local level for this?
Sure. I've been very fortunate to serve on both city councils one on the West Coast and also one on the East Coast, one in a non-right-to-work state and one in a right-to-work state. And from my experience with that, I want to talk about the application in regards to economic development, in regards to local governments, and why there maybe has been kind of a pullback by local officials in addressing this issue. Businesses looking to set up shop in a community look for stability. They ask themselves questions like, do they offer low tax and fee structure? Is the cost of living for their employees reasonable? Is the town or county government predictable in their public policy? And probably the overriding question is, what is the cost of doing business in this community? Cities and counties in non-right-to-work states are at a competitive disadvantage to those cities and counties who are in right-to-work states, as has been explained. Because, as it stands now, the only leverage cities and counties in non-right-to-work states have is to use taxpayer money to lure businesses to the area. They often use subsidies, tax incentives, deferments on fees. However, using these criteria, it is only the largest counties and cities that can give away substantial taxpayer perks. So the medium and small cities and counties are left with no real economic development plan. But what if cities and counties in non-right-to-work states were able to pass an ordinance making their jurisdiction right to work? All of a sudden, you have jurisdictions who are competitive, and they drive down the cost for local government and also may free up extra money to help build that infrastructure for economic development. At this point, you see large businesses such as Boeing looking at neighboring communities rather than looking across the country for a place to set up shop to expand their business. In working with local officials across the country, I have come to realize that many of them do not fully understand how much leeway they actually have in decision-making, such as RTW, mostly because it requires some heavy lifting when it comes to public policy, because Political allies, legal and legislative resources are in short supply. I believe this is where these organizations that are represented here today can help step up and to help advance RTW on the local level. The American City-County Exchange, which I'm the director of, is a membership organization of local elected officials who develop public policy rooted in free markets and limited governments. Our parent organization, ALEC, has model policy on RTW for the states. It's very plausible we could see model policy available for local governments in non-RTW states. This could also be used as a template for citizen organizations looking to pass a local RTW via the initiative process. The possibilities of rolling out a local RTW in a non-RTW state deserves a full court press by those of us who care about free market economics and allowing communities to make the best decisions for their people. Thank you.
Well, thank you. And with that, we'll open it up to questions from the audience. Sorry, is there someone here with the microphone? Okay, normally there's.
I don't see a microphone, but hopefully it'll pick me up. I'm Slim Firth from the Heritage Foundation. I'm curious, maybe John or Bill could speak to this. Approximately what share of non-right-to-work states would have the opportunity under state law to make labor rules internal? Do you have some kind of ballpark figure?
Do you know? I wish I could provide an answer, but I don't. It really goes into, the power of, each state subdivision within a state, and it could vary. You could have home rule cities in a state and some counties which are considered political subdivisions. So it would really vary, state by state. New Mexico seems like it's okay, given that they've tried it there and they only ran into federal issues. But once you leave there, I couldn't tell you off the top of my head what, Kentucky or Missouri or anywhere else.
Well, I'll add in just briefly a few. Clearly, New Mexico has home rule cities. Pennsylvania has charter counties. Ohio has charter cities. Kentucky has charter counties. So there's a number of states in what you might call sort of middle of the road, philosophically and ideologically. We've got charter cities and home rule counties and the like. Now, we should be very clear that, let's say that someone comes along in California and tries to do this. Obviously, a very liberal state. Even if the California Constitution granted them the authority to do it, the legislature can very clearly turn around and say, no, you can't do that. No going there. That as long as the legislature is silent on the question, then the cities are free to act. But if you were to take a state like, say, Massachusetts, I have no idea if they have home rule cities or not. But if in Massachusetts or California they were to pass this, I would have great difficulty imagining the legislature not immediately turning around and saying, you don't even try it. And so there may be, whether or not there's a state constitutional division of powers issue, clearly the state legislature trumps local law. And there's, beyond the sort of, are you charter city or not, that would also be a consideration.
Yeah. I think fundamentally, we are looking at, it's not exclusively, but we are looking at those purple states where you have a large urban area and some outlying areas are just don't want to be under that same regulatory burden and would like to jumpstart their local growth. I'm thinking of states like Illinois where you've got a legislature that's not complete. It's not red, but it's not completely crazy. Also, New York City or New York State versus New York City. Some locales there might want to take a look at this sort of thing. And one last point on state preemption of local ordinances. I have noticed that some states have home rule, blanket home rule. Some have home rule with respect to certain issues. Mm-hmm. It might be the case that locales are authorized in a state to pass lots of things with respect to education or this or that, but not with respect to labor, or only with respect to labor, but not with respect to education. So it's a very complicated area, and folks really do need to take a look at their state law.
The gentleman at the far back there?
Thank you. Can you hear me?
Yeah.
Yeah.
And if you could state your name and affiliation.
Sean Higgins. I'm with the Washington Examiner. I arrived a little bit late, so I apologize if this was already addressed earlier. But how often have actually localities tried to do this? How many have attempted to pass right-to-work ordinances or something similar?
Well, I don't think that there have been too many of them. It would be this sort of piggybacks on the last question, but I did point out that there was the first court case that we have even dealing with the general issue that we're talking about today was a 1965 case out of Kentucky where a locale tried in Kentucky to pass a similar ordinance. Then obviously we have a few in New Mexico, and the issue arose in Missouri. But local officials are generally quite conservative folks. Many of them are part-timers. They don't want to rock the boat. They've got small budgets. They're worried about legal fees. And really, the default for many local governments is do nothing sometimes. So it's not surprising to me, given this complicated area of law, given other pressures, it's not surprising to me that there hasn't been too much activity on this front.
Terry Miller from the Heritage Foundation. The economic advantages for a locale that did this in terms of attracting new investment are obvious. But I'm trying to understand a little bit better what the reactions might be of existing businesses in a locale, perhaps businesses that already had a closed shop contract of some kind. Would that be preempted by a law like this? Would that contract be immediately abrogated? And what would be the likely reaction of these existing businesses?
Well, to speak on the contracts clause issue, just legally, most right-to-work laws now have contract clause exceptions saying they only apply to contracts entered into after the effective date of the law. If it went and actually invalidated an existing contract, then basically contract clause analysis is very case-by-case dependent. It'd be hard to say, yes, for sure, the contracts clause would say you can't do that or that it would. So it's difficult to predict how that case would come out. I'm sure the unions would sue over it. But most of the laws now have that savings clause to it with the grandfather clause that gets around the issue.
Yeah, the smart way to do it is to have it be prospective. And it's smart for a variety of reasons. But one of them is just to explain to folks this is about choice. It's not about taking away something that you already have. It's not about hurting unions. The idea is to provide choice for folks, choice going forward.
Yeah, if you have an already unionized facility, it's not going to affect the business much at that point. The economic development benefits for a city or a county would come from attracting new businesses who wouldn't be as concerned about hyper-aggressive union organizers. But from the business's perspective, it's not going to change their life much at all. It's the workers' perspective who then actually have the choice. Do I want to give $800 a year to this organization or not? Would I rather spend that money on my family or take a vacation at the beach? Or how do I want to spend my own money here? So the workers would be affected in a county, or rather in a business that's sort of being unionized. The employer himself probably wouldn't notice much of a difference one way or the other. Are there additional questions?
Hey, Alex Bolt from the Competitive Enterprise Institute. My question is for Mr. Messenger. Just wanted some clarification on the argument for how the NLRA doesn't preempt these local right-to-work laws. Is it because, could you just expand on the relationship between 14B and 8A3 again?
Sure. So 8A3 has an exception to it called the union shop proviso, which says that nothing in the National Labor Relations Act makes it illegal for an employer to enter into a compulsory unionism clause. And then 14B creates an exception to that exception, which says nothing in the National Labor Relations Act authorizes a compulsory unionism agreement in any state or territory where such an agreement would be prohibited by state or territory law. So 14B basically allows states or localities potentially to, prohibit the union shop agreements otherwise authorized by the proviso to 8A3, which in turn would otherwise be prohibited by 8A3. So the argument for a local law is twofold. One is a local law would be a state law for purposes of 14B, that the greater includes the lesser. And then the second argument is that even without 14B, the Supreme Court has held the National Labor Relations Act, 8A3, doesn't necessarily preempt state regulation of compulsory unionism agreements. And again, in that case, they upheld a dozen right-to-work laws. Well, there's one right-to-work law at issue, but there's a dozen in the country at that time before the enactment of 14B. And so those would be the two arguments. Now, those arguments were also made in the district courts and state courts. They did not prevail. But again, the issue hasn't worked its way up to the appellate courts or Supreme Courts, and I think the arguments are viable.
Gerald Chandler. Do you think there's an economic downside to having various varying rules from city to city within a state? If you have, as you've proposed here, each city has its own laws, you can imagine, as we already have, different cities have their own minimum wage laws, they could have their own health laws and so on. So can you address the total issue? Would it be better economically to have a one consistent set of rules for a whole state?
The point is, I think here, and that's one of the arguments that was made by the District of New Mexico, the federal court in the city of Clovis case. The point is that Congress explicitly made clear by passing 14B that they were authorizing at least 50 states to have different schemes plus the territories. That's the minimum. So we're already talking about a variety of different schemes, and there are burdens associated with that. Certainly, we know that major multi-jurisdiction employers such as McDonald's are always lobbying in favor of federal preemption, generally speaking, because it's cheaper to comply with only one scheme rather than comply with 50 schemes. That makes perfect sense. On the other hand, it's up to Congress to make these choices. Congress made the choice to allow at least 50. Certainly we know that I can't think of an area of law where there are 50 different schemes, and RighttoWork is no exception. There are only a handful of different types of schemes out there. So if the fear is that by authorizing locales to pass RighttoWork that we will end up with thousands of different models, I think that's unfounded. More likely you'll end up with 3 or 4 different models, and it will not be incredibly onerous on employers to comply with these sorts of things.
Yeah, I mean, the business is going to know what's the law in your jurisdiction. It's going to be fairly straightforward. Either the contract can you tell the workers they have to pay union dues or they can't. There's basically going to be no administrative expenses for the businesses that have to deal with it. And beyond that, we think it's good policy. I mean, the concern with a lot of these, a patchwork of local policies generally comes from when they're a bad policy. This is something that we think a state would be better off with some RighttoWork counties than none whatsoever. It would probably have the effect. Let's say you've got a half dozen counties in, say, southwestern Ohio pass RighttoWork. Well, that's going to put a lot of pressure on counties in the rest of the state and their neighboring counties to pass RighttoWork themselves, because not only are they now competing with, say, South Carolina and Tennessee on an equal footing for plant location decisions. If you've decided you want to locate your plant in Ohio, where do you think you're going to locate? Well, you're probably going to locate in one of those RighttoWork charter cities. So it would put fairly strong economic pressure on their neighboring counties to pass RighttoWork, but generally, as speaking, we think that's a good thing. We think workers ought to have the freedom to decide how to spend their own money, that you take a look at how unions, in many cases, spend the union dues, and in many cases, Department of Labor filings show that the Service Employees International Union gave $25,000 to fund the daily operations for Planned Parenthood, America's largest abortion provider. Now, whether you're pro-life or you're pro-choice, I think it's very reasonable to say that people who are pro-life shouldn't be forced to send money to subsidize an organization that is giving money to perform abortions. And no matter where you stand on the morality, the legality of the issue, there's very strongly held feelings on this issue. And people ought to have the right not to support organizations whose values are directly contrary to what they believe in. And so we think expanding individual choice and freedom in this regard would be a very good thing. If you can't get it at the statewide level, the locality level is the next best thing.
Good. I'll jump in there as well. If you start having counties, cities start developing this, you create an upward pressure. Much like some of the other issues, regardless of if you agree or disagree with it, the smoking ban issue was a huge issue back in the 90s, 2000s. Most of that was generated from the grassroots level, from the counties and cities, and it was upward pressure that eventually got the states to start acting on the smoking ban ordinances. Same theory, definitely the cause that we're advocating is more freedom versus more restrictions. So it's the same theory of causing an upward pressure on the state legislature to move and to act on it.
We've seen a couple of, I would guess you would say near misses regarding, union shop clauses and the right to work issue at the Supreme Court level and Mulhall and Harris v. Quinn. Do you guys think that if there would be these sort of local level ordinances that would increase the amount of litigation and eventually cause some case that would rise back to the level of the Supreme Court and force them to readdress this issue?
Well, I'd say that it's always possible. With the preemption issue of whether a local right to work law be preempted, if you did have several of these coming up in different places, that could be something the Supreme Court would take. The Supreme Court primarily takes cases if there's a conflict among circuits, or if they think there's going to be a conflict because basically the same issue's popping up all over the place. And so if you did have that, you could have that preemption issue arise. The direct challenge to whether compulsory unionism is constitutional probably wouldn't come up through this framework. Here we're talking about prohibiting it. Most likely that challenge will come through the public sector cases, dealing with whether or not the government can force its employees or providers to pay compulsory fees.
Yeah, and ultimately, if this does ever get heard squarely by circuit courts or by the Supreme Court, whichever way they fall in interpreting this provision, whether they say that local right to work is preempted or not, it is always permissible for Congress and the President to go back to the drawing board, because this is not a question of constitutional rights. This is a question of what is Congress regulating as a matter of statutory law. They can change that. They can go back. If it turns out the Supreme Court says that they are preempted, Congress can say, heck, we want to encourage more innovation. We can go back and repeal this or change it. If, on the other hand, the Supreme Court comes back and says it's not preempted, and you get a Congress that wants to go back and preempt it, they could by all means do that.
Yeah, again, it's only a handful of times we've got only one federal court case directly on point, and then the Court of Appeals handling the related but not identical issue of Indian tribes. It's not that surprising, since it hasn't been tried that much, that the Supreme Court hasn't ruled on it. If you were to see a large number of cities and counties trying this, I think that would greatly increase the likelihood of both courts of appeals and then potentially the Supreme Court to deal with it.
There's an implied question in there, which is, if you're a local lawmaker and you're considering one of these proposals, how concerned should you be about attorney's fees potentially? And I imagine that there would be organizations out there that would provide perhaps pro bono representation for these folks defending these ordinances.
Well, I can't directly speak to that. The Right to Work Foundation represents individual, employees, but obviously, believes, is a strong defender of right to work laws. Obviously, the bigger the better. A national right to work law would be best, followed by a state right to work law, because there's really few legal problems, at least on a federal level, with those. And so there's an issue. But the attorney's fees issue is one for a local lawmaker to consider. If a union did challenge a local ordinance as being preempted, it would bring that suit under Section 1983. That's an attorney's fees case. So if the union was to prevail, the locality would probably not only have to pay its own attorney, but also the union's attorney. And I guarantee that case the unions would litigate it until the bloody end. So that is something to consider, if you are a locality. Thinking about that is that you will be in for a legal fight.
Any more questions? All right. Well, Bill, just before we close, if you could address one of the union arguments that we hear time and time again, whenever how do you justify forcing someone to pay you dues? Well, what the unions always says, well, it's a free rider problem, that the law requires them to represent all these workers, and therefore, if they're required to give you services, that you ought to have to pay them for it. Could you address this so-called free rider problem?
Absolutely. And I think, the flaw in that argument is that exclusive representation is not a burden for unions. It's an incredible power. It's basically a monopoly. Another name for exclusive representation is monopoly representation. It means the union has the power to speak for everyone in a bargaining unit, whether they like it or not. And not only that, the employer has to talk to the union whether they like it or not. So that's an incredible power that unions want, including in right-to-work states and in the federal government, which is also right to work. And so for the unions to turn around and complain, heavy is the crown, I deserve money from the people I'm forcing my representation on, it's really hard to accept. And there's all kinds of analogies, that are used for that, but it's sort of a lot like a kidnapper, saying that their victim should pay them room and board. Well, they don't want to be there in the first place. And it's the same idea. You know, it's the unions that are imposing their representation on these employees. And it's an incredible power for the unions, which allows it to gain more members than it could otherwise gain. And so for it to turn around and say that people are free riding off a service they never wanted in the first place, I submit is untenable. And hopefully eventually the Supreme Court will agree with that across the board.
It's also worth noting that the Supreme Court has repeatedly ruled on a question of whether unions have to be exclusive representatives. And cases from the 30s, cases from then through the 60s, the Supreme Court has repeatedly ruled that if unions don't want to be an exclusive or monopoly representative, they don't have to. They can negotiate a contract that only represents their members and leave the non-members free to negotiate on their own behalf. They almost never do this. And the reason they don't can be illustrated by, say, a union seniority system. The fact is in that in most union contracts, they provide benefits to some workers, not at the expense of the company, but at the expense of their fellow coworkers. So with the seniority system, you basically guarantee that the first people to get laid off are the new hires. Well, if I've been around at a company for 10, 15, 20 years, I like a seniority system. It means that even if the company comes in rough times, I'm doing pretty well. But if I'm a new hire, I do not like this. I would much rather have performance-based layoffs rather than forcing me to walk the plank. So if the union did not negotiate as an exclusive representative, the new hires, if they thought there was any chance of layoffs, would immediately opt out. And then the workers with 1 or 2 years experience would opt out. Then the workers with 3 or 4 years experience would opt out. And pretty soon everyone opts out, or the union can't put a seniority-based layoffs clause there in the first place. That the unions want to be an exclusive representative because it allows them to force the workers who get hurt by their contracts, in this example, the new hires who get first to be laid off, it allows them to force them to accept that contract and not opt out of contract terms that actively hurt them. To then turn around and say that the union gets to charge those workers they hurt forced dues in order to fund a contract that guarantees that they get laid off if the ship runs into any stormy waters, that strikes me as a fairly outrageous argument. And it's also worth noting rather insincere on the union's part. After Michigan passed RighttoWork and the union screamed about free riders, the state legislature, some of the conservative lawmakers started saying, well, hey, you know what, why don't we just get rid of exclusive representative for government employees? And the unions immediately turned around and said, no, that's not what we meant. No, don't do that. We only care about, basically, we think this is an argument against RighttoWork, but we don't actually want you to take away exclusive representation. And that's, it's the immediate union response to how they justify forced dues, but I think really what they want is they want the money. And they do not at all want to stop representing the workers who are forced to pay them dues. And with that, thank you everyone for coming. I believe we've got some sandwiches and refreshments outside.